Hello, I'm Ron Tasoff. I'm a partner in the immigration law offices of Tasoff and Tasoff. We're one of the oldest immigration law firms probably in the country, founded by our father back in 1949. I'd like to talk a little bit today about how you can get a green card through job skills. As I mentioned in another video, there are non-immigrant visas that allow people to work in the United States. The H-1 visa, there's also the F-1 student visa, practical training, treaty trader, intra-company transferee, trade NAFTA, which is for Canadians and Mexicans. All of these allow people to work in the United States, some for limited periods of time, others somewhat indefinitely. However, many people working here want to eventually become U.S. citizens and, of course, do not want to be tied to a specific employer or other condition that allows them to work temporarily. What they need to do is become a permanent resident, get their green card. Getting a green card based on job skills basically requires two ingredients. One, you have to have job skills, and two, you need an American employer willing to sponsor you. And probably three, most likely you'll need a lot of time because for many of the categories there's a quota. There are basically three types of employment-based visa preferences. They're called basically the employment-based first, second, and third preference. The first are for special categories of workers, such as researchers, intra-company transferees, aliens of extraordinary ability, and other very highly skilled occupations. The second category is for aliens with advanced degrees. Usually this means a master's degree or above. And the employment-based third preference is for people who are professionals or skilled workers. There's also a subcategory of the third preference for unskilled workers. It has its own separate quota, and that quota can be very oversubscribed. We don't have very many unskilled worker cases anymore, although they're still in the law books. Usually we can show that a person has skills. Now, what type of skills are we talking about? Well, basically it's anybody who's done something for more than 2 years and can get a job offer from an American employer that normally requires 2 years. Now, how do we find out what types of job requires 2 years? The Department of Labor has their tables and occupational guidelines, and we can find out pretty much for any occupation, at least the occupation that we're going to be dealing with, what the Department of Labor says is the minimum entry level. If that minimum entry level is at least 2 years of experience, then that job qualifies for the employment-based third preference. Some categories of jobs would include specialty cooks, of course professions like architects, teachers, computer information scientists and so forth, computer programmers, and they would all fit in the employment-based third preference. If we can show that the job requires an advanced degree, at least a master's degree, and our client has a master's degree or the equivalent of a master's degree, then we can get the client qualified under the employment-based second preference. Besides the different skill levels necessary to qualify for one of the employment-based preferences, the other difference between them is the number of visa numbers each of these preferences is allocated. Currently, the first and second preferences are pretty much available, quota numbers are available, except in the second preference category for people born in India or China, mainland China. Thus, if we can qualify a person under the employment-based second preference, there usually is no quota backlog, and once the application can be filed, the person would be eligible to apply for adjustment of status and a work permit not only for themselves but their spouse and dependents. Unfortunately, the employment-based third preference for professional workers with bachelor's degrees and skilled workers with at least 2 years of experience, that quota can be backlogged several years. It changes every month, and as a result, normally we have to have the client obtain a visa category that allows them to work in the United States while we're waiting for a quota number to become available. Oftentimes, that non-immigrant category is the H-1 professional working visa. There's a separate video that we made on that topic, and please view that to find out more about the H-1B visa. Many of our clients go from F-1 student or even tourist to green card status. However, they have this period of several years where they need to work in the United States, oftentimes for the employer sponsoring them, and that period of time can be covered by the H-1 visa.